Good afternoon, and thank you all for joining us today. So before we get started, I would like to acknowledge the traditional owners of the lands on which you and I are respectively dialing in from today, and I pay my respects to elders past and present. Next, some administrative housekeeping. We have you all, I think, able to unmute and turn on your videos, I believe. But for the most part, if you could just keep yourself muted, cameras on or off, either way, that's okay. We'll have question time towards the end, and we have 20 minutes for that. So if you have any questions, please put them in the chat and we'll collate them. And if there's a particular question that's very pertinent to the point being spoken to, then we'll try and address that straight away. If not, we'll leave it to the end. And yeah, we've got myself, Grace, the IP Australia team, and Michael today here to present to you. And as you all know, some of you who have been with IP Insiders for a while, we like to do things a little bit different. And today, with the generous support of IP Australia, who is our co-host and partner, we are bringing to you what we hope is a little bit different to the usual webinar on legal practice and legal precedents. As in-house professionals, we are often asked to advise not just on the details of prosecution of IP, but also about how IP fits into commercial, regulatory, economic, and other environments. And I believe in order to make good decisions in these areas, we have to understand the trends that are shaping IP use predominantly in Australia, how those trends interact with innovation and I guess the economy a bit more broadly. So IP Australia recently released the Australian IP report. I think this was just in August or September this year, so it's very, very new. And this report is basically the most comprehensive snapshot we have of how Australians are using the IP systems, what trends are emerging, and how these trends connect to innovation, resilience, productivity, etc. And I think this is the kind of data that us in-house professionals really need to advise our organizations on. So to give us an overview of the findings of this report and to help us better understand it, we have none other today than the person who put it together. So Dr. Michael Falk, the Chief Economist at IP Australia. So Michael leads the IP Australia's program for economic evidence and advice. Michael has a PhD in Management of Technological Innovations from Melbourne Business School, which I think second only to AGSM in Australia. He has a background spanning research, strategy, and communications across government. And Michael also serves on the advisory board of IPREA at the University of Melbourne. So Michael, we really appreciate it and we thank you today for giving us the time to go through this report with us. And I'll hand it over to you.
Thank you, Brendan. And thanks to IP Insiders for collaborating with us on this session. Thanks everyone for dialing in and joining today. Before I begin, I'd like to acknowledge the traditional custodians of the land that I'm speaking from, the Wurundjeri Woiwurrung people, the Kulin Nation here in Melbourne, and pay my respects for their continuing culture and contribution they've made across innovation and cities and regions across Australia. I also acknowledge and welcome any Aboriginal and Torres Strait Islander people joining us today. So today I'm presenting findings from the 2025 Australian IP report. And this is IP Australia's flagship annual publication. It brings together the latest statistics on the use of intellectual property rights in Australia, including patents, trademarks, designs, plant breeders' rights, as well as copyright. And we put it in context of current developments and trends in the economy, technology and trade. We also feature new research by IP Australia and by our external research partners that explores how the system functions and its broader impacts in the economy. That's to inform policy decision-making, but also to inform practice, both within the administration of the system and within industry in understanding how IP data can be used to inform commercial decisions. So the theme of this year's report is flexibility. It's about how the IP system is designed in ways that accommodate needs of diverse innovators. And we show that firms who use this flexibility well, that adopt a proactive IP strategy, understand the system, and make use of its many flexible options, tend to achieve stronger economic outcomes. That includes more innovations, more commercialized products being brought to market, and greater lifetime value generated from their intangible assets. Towards the end of in the latter half of the presentation, I'll present some of the research that really speaks really strongly to these outcomes. But I suppose to put this in context, we are, it's not uncontroversial to say that we're in a period of profound global economic uncertainty. And as this chart shows, global economic policy uncertainty over time has spiked in the last year. And that's primarily driven by trade policy uncertainty linked to US tariffs and the prospect of global tariff wars. But underneath this kind of trend, there's really uncertainty across the board in terms of national security, in terms of fiscal policy, in terms of the regulatory environment, and monetary policy. And this is uncertainty that businesses are navigating in seeking to enter new markets, in seeking to export, in seeking to start up their businesses. So it is really a period where flexibility and the adaptability of the IP system becomes crucially important. IP rights provide not only strategic flexibility in helping firms manage risk, in helping them to attract capital and scale their innovations, it can also act as a store of value for firms in periods of uncertainty if they can later recoup their investments in knowledge through licensing and trading of IP. We saw this dynamic clearly during the COVID pandemic. Here you can see filings across patents, trademarks, and designs, where the application numbers, the annual application numbers are indexed to 2015. And from 2020, you can see there's a very clear jump. There's actually an upward shift in the level of annual applications we received across patents, trademarks, and designs. So the trend kind of shifted up a level. And that's obviously a spike that coincided with the shift of the global economy online and surging demand for digital and health technology solutions to meet the needs of a global economy that was in crisis. And what's striking here is that this all occurred despite recession conditions. In particular, the surge in trademarks was in particular unexpected in many ways and counter-cyclical. From the observation of trends and from prior research, IP filings tend to be pro-cyclical. And last year we published a new study which showed that trademark filings in particular are a leading indicator of the business cycle of where the economy is headed in the short term. But during periods of uncertainty, IP rights can also act as insurance for investments in knowledge. So firms, in particular where firms are able to later recoup those investments through IP trading or licensing. And so, the capacity to store value in IP as assets can provide some incentive to invest in innovation during periods of uncertainty. By 2022, we saw some correction to that elevated filings, and that was as inflation hit, as financial conditions started to tighten. But if we look at the trends from last year, from 2023 to 2024, then we see that there's been some renewed growth. In particular, design filings were up 9% last year. Trademark filings were up 3%. Patent grants jumped by 24%, and that was partly due to productivity improvements in examination here at the Patent Office. And some of the research I'll present later really puts into perspective the economic importance of these productivity improvements. So this table is a feature in the report. We provide it each year, and it really, in a succinct way, provides figures for filings in the last year, both application numbers and grants, the total numbers and growth that we're seeing across the rights. And then it provides that in aggregate as well as for Australian and foreign applicants. So that's a very useful resource for getting just a very simple picture of the last year's IP activity. So the big structural story really is international. And so let's start with the United States. Last year, patent filings from US applicants in Australia fell by 6%. And if we look at this year, those applications from US applicants were down 12% in the June quarter compared to the June quarter last year. So we're seeing continual moderation of US patenting activity in Australia. Most of that activity is in pharmaceuticals, it's in medical technology, biotechnology, and computing. And all of those field applications across all those fields declined last year, except for biotechnology, which remains strong and actually a source of strength in domestic filings also, speaking to, I guess, the resilience of that as a technology field, where, of course, it has applications across many domains. And of course, you know, those declines that tapering in filings from the US, there's good reason to expect will continue as we're starting to see manufacturing employment in the United States start to decline, and of course the disruptions to the science and research system there. There's a study from the United States which shows that about 30% of patents in the United States can be traced back to federally sponsored science and research. So there's obviously sources of significant change in the global context that we can expect filter through to filings here in Australia. If we look at China, then we find that across the rights there's been really significant growth in applications. So in 2024, filings from China rose by 5% in the case of patents, by 45% in the case of trademarks, and by 66% in the case of designs. Trademarks and designs from China are essentially doubling each year. Now, that's linked to the recent boom in e-commerce from China, and there's some evidence that some of the growth is linked to use of trademarks, for example, by vendors to gain access to the Amazon brand registry, where they can sell goods and services online, and a lot of the growth in trademark and design filings from China is concentrated in household items. But we're also seeing that growth linked to China's long-term investments in sectors like transport and clean energy. So as many of you will know, China has been, since at least 2015, heavily stimulating certain high technology and manufacturing industries. That's been accelerated as China's been trying to confront some of the built-up risk in its property sector. It's moving some of those investments into high-tech and manufacturing, leading what some analysts suggest is overcapacity in those sectors that's driving a surge in global exports. And as tariffs are raised against China across the US and the European Union and other economies, we can expect some of that trade to be routed into Australia and alternative markets. And so you know, what we can zoom in here specifically to the story of electric vehicles, because we see that in Australia, trade in electric vehicles and parts is a really significant source of growth in filings across the registered rights. In fact, 2024 saw growth in transport and vehicle categories, including 10% growth in trademarks, and Chinese filings in this category were up 79%. Transport overtook computer equipment as the leading product class for new design filings, and BYD, the Chinese EV producer, has entered our list of top design filers for the first time. So we're really seeing structural shift in Australia's sort of, the partner structure and technology structure of Australia's trade, and that's being reflected through in the new IP flowing into the country. Using a novel machine learning approach, we've analysed the patent data beyond the sort of simple, typical technology codes, and we've found that China has outpaced other countries for EV patent filings in Australia, with filings in this category from China growing at 75% per year. And that compares to 44% for domestic innovators. In fact, Australian innovators are run second for growth in this category, and then 38% for the United States. Now, there's good research in economics which suggests that the IP system, as well as facilitating foreign direct investment and sort of access to global technologies, also has an important role in the upgrading of technological upgrading of domestic firms, and that's an important precondition for countries to benefit from technologies overseas. I think what we're also seeing here is, not only China's increasing dominance as the kind of source of electric vehicle technology, but also the efforts by Chinese EV producers to build global brands. And that involves not only adapting technologies and designs to local market standards, but also adapting the kind of the brand language, the marketing language, and how those products are commercialized within domestic markets. And so we're seeing this growth in IP really across the different rights. Alongside that, of course, we're witnessing the huge wave of US investment in artificial intelligence, which one source estimates was around $141 billion borrowed by US AI-related firms to fund investment in AI. And so, there's opportunity here, of course, immense opportunity to drive innovation across fields and across application sectors, but also a huge amount of speculation and gambling. If this is a chart from a study we released last year by some partners at Swinburne University, looking at trends in patents for computer implemented inventions here in Australia, as well as at the EPO and USPTO. And what this chart shows is that, in this study broadly, we find that about over 30% of patents filed in Australia today are for computer implemented inventions, and those inventions are not only concentrated in computer technology, but are indeed distributed across a range of fields. And this shows per field what percentage of applications filed are for computer implemented inventions versus non-CII inventions. And then we've broken down the CII inventions by first those that would be likely clear of clearly patent eligible subject matter, and those that are really at the margins of being patent eligible subject matter. And this is based on a machine learning approach where we looked at applications that actually received a manner of objections at IP Australia for as not being manners of manufacture, and then we use that as data to train models that identify patterns that are similar to that, both here in Australia as well as in patents that are filed in other jurisdictions. And you can see here that the CII applications are a significant share of applications in computer technology, but actually also in medical technology, in IT methods for management, in control, audiovisual, and telecommunications, as well as electric machinery and transport. So that study, the source is provided on the slide, and I'll be sure to share these slides so that people can check out the fuller reports. So how are, these global trends are reshaping competition, and how are Australian innovators faring? In the domestic filings, what we are seeing is, while they were fairly flat last year, particularly for patents and trademarks, we're seeing significant growth in domestic filings this year. In particular, a 31% increase in June for patents compared to June last year, and that follows a 36%, and then a 36% increase in the September quarter this year. And we can look at this in real time. So I'm going to show you a new product that we have published. Okay, so this is a product called the IP Rights Overview. And it's a publicly available dashboard. You can get online and look at it now. And I'll just show you what it provides. This is presenting data that is updated weekly. So it's a real-time snapshot of the latest trends. I've got this set to the last financial year. I have also got it set to the fourth quarter of the last financial year, so that's actually the June quarter of this calendar year. We can set it to show data trends for a specific origin. So if I show it for Australia, and we can set it so that it will show particular classification trends for patents. As well as, so here it's giving us option to filter down to particular technology fields. And what we can see is that, in the June quarter of this calendar year, so in our last June quarter, there was a 31% increase in patent filings compared to June of last year. We can look at the kind of trend over time and see that there's been this recent uptick in domestic patent filings. We can see who are the lead patent filings in this particular quarter, with Aristocrat, some private applicants, as well as University of Queensland, University of Melbourne, leading the ranks, and then what's the kind of ranking between states and territories in terms of their patent filings in the quarter. We can do the same for trademarks, and it will show us the trend in trademarks, and it will eventually update to show us. We see Pharmacore as well as Aristocrat, and some new entrants actually into the list of lead filers there. We can then update to this calendar year, and if I set it to the first quarter, that's the September quarter that's just passed, we see that there's a 36% increase in patent filings in the last quarter compared to the same period last year, and trademarks up 15%. So we're seeing some pretty significant growth actually in domestic IP applications, patents and trademarks in particular. So we'll put the link to that in the chat so that people can have a play. And I'll just jump back into my presentation slides. Okay, so looking at the domestic innovation sector, there's two big trends that stand out from our recent research. First, we're seeing a very clear shift in who holds patents in Australia away from large firms towards small and medium enterprise. SMEs comprised 85% of patenting firms today, and that's up from 80% in 2005. And in fact, what this chart shows is the growth in the number of SMEs that hold patents in Australia has outpaced growth in the total number of SMEs, and the opposite is true for large firms. There's been some weak growth in patent participation among large firms. That's as they've tended to exit the research game, even as the number of large firms in the economy has increased. And so innovation in Australia is increasingly driven by small firms as the kind of engine of innovation, and is increasingly a source of differentiation among larger corporates. The second trend I'd mention is we've seen that the overall share of patent holding firms in the economy has fallen. But if you look a bit closer, participation has actually increased in traditional patent intensive industries. That includes in manufacturing. So a larger share of firms in manufacturing today hold patents than they did in 2 decades ago. And it's particularly the case in professional, scientific and technical services, where the share that holds patents has doubled since 2003. So if you take these trends together, we think what it points to is a rise in the importance of startups and small knowledge-intensive firms in developing technology that's probably later scaled by corporates. Acquired and scaled by corporates with existing capacity and resources to commercialise those ideas. This is consistent with research from the United States, which says that there's been a sort of increase in division of innovative labour, and that's of course enabled and facilitated by the patent system as well as by the other industrial rights, to the extent they allow for technology, trade, and licensing. It's also the case that in insulating firms from imitation and in allowing them to trade their IP, the IP systems can provide much needed time for smaller firms to build those commercialization capabilities, if that's the way that they choose to take their ideas to market. So given these trends, we wanted to understand how different innovators use flexibility that's built into the system. So I'm just going to play a short video case study with an Australian startup talking about how they've managed IP timing.
Per capita, Australians are the highest consumers of textiles anywhere in the world. In Australia, about 1 million tonnes of textiles go into landfill, and it's projected globally by 2030 that number will raise to 140 million tonnes per year, which is just frightening. BlockTex's mission is very simple: divert textiles away from landfill. BlockTex is a clean technology company, and what we do, we've developed a technology to separate the hard-to-recycle blended fabrics that we use every day. Our IP protection obviously is continually in development because we're a cutting-edge technology. Our chemical separation process is called SOFT, and it's an acronym for Separation of Fibre Technology. We've used low-grade chemical process combined with a variety of conditions to allow us to unlock the cotton from the polyester. Our ability to unlock the polyester from the cotton and get that back into a recycled stream is really critical for that transition. BlockTex has currently got 5 registered trademarks. BlockTex, our name, Polytex, our cellulose brand Celtex, blockchain process Tracetex, and our wonderful business-to-consumer initiative we do with local councils all over Australia called Give a Sheet for the Planet. BlockTex looked at both registering the trademarks by ourselves and also what it would cost to use a trademark attorney. I think if you're an early stage founder, without the experience, I would advise that you go and seek the right amount of expertise. We currently have 2 patents pending. The patents are really important not only from the comfortability for our investors, but equally important as a business to show maturity, that you have thought about what you're trying to build, how do you protect it, and to ensure that you're not infringing on somebody else's patents. It's been a roller coaster of success and failure. Ultimately, we see this as the stepping stone into building Australia's first textile recycling industry. Block-tech should be a verb. If you've got unwanted textiles, block-tex it.
So these are case studies that we developed by our web multimedia and design team. They're really great. The visits to the factories are always a really enriching experience. This particular factory was interesting in that they'd taken machinery from a broad range of different sectors, whether it be from commercial laundry, from brewing, and coupled it together in a way to make this textile recycling a kind of at scale, a reality, a really interesting example of recombinant innovation. And I know that there's people on this call that will have as equally fascinating stories about how companies are applying IP and the considerations that they have in both pursuing IP and in taking their innovations to market. So please get in touch if you think you have stories that would make for a good case study. For us, one of the reasons we wanted to highlight this story in the context of this year's report was just how it highlights how much thought that goes into timing when it comes to when to file for IP rights, how quickly to progress applications, how the kind of IP process aligns with pursuing funding and keeping kind of optionality while learning about the market. And that's really the focus of the research feature in this year's report. Obviously, that flexibility around timing is deliberate. It's built into the system. Applicants can delay or they can accelerate examination. And the reason that we provide that flexibility is to give a window so that businesses can assess the commercial potential of their inventions, to amend applications as they learn about technology needs in the market, and to withdraw low-value inventions that aren't going to succeed in the marketplace. So we don't have low-value patents that are being pursued, creating kind of uncertainty in the market. And so recently we commissioned a major econometric study from some research partners, really some of the best in the new generation of IP economists internationally, at EPFL in Switzerland and Motu in New Zealand. And they have done a study looking at 316,000 patents granted in Australia between 2004 and 2016, as well as using data on the equivalence of these patents that are granted in other jurisdictions. So that is patents for the same or similar inventions that are granted overseas. And we looked at what are the drivers of behaviour among different groups of applicants in choosing to accelerate or to delay the patent process, and what are the outcomes of delays in terms of the renewal lifetime of the patent as a kind of indicator of its lifetime value to the firm, in terms of the likelihood that the patent will be commercialized in the form of a product. And for that, we used data on virtual patent markings, particularly for products commercialized in the United States, where the data is that data is most complete. And then also looked at to what extent post-grant these patents are built on through follow-on innovation efforts both by the applicant and by their competitors. And for that, we used citation data in global patents. And what we find, it's often, you sometimes hear among commentators and some policymakers, there's a kind of view that it can take a long time to get a patent, and for that reason, patents are not so relevant in your fast-moving technology fields. When we look at actually what is the median time between when an applicant requests for examination to commence and when the patent is eventually granted, that median time is 1.3 years. And about 80% of the total time that a patent is pending is actually time where the patent is sitting with the applicant, waiting for action from them to be progressed. Now, I'm sure that this is not news to people on this call, but they are interesting stylized facts about the pacing of the patent process. When we look at the kind of outcomes of delays, we find that those patents that are accelerated, for example, through the fast track program, they tend to perform better. They're renewed more often. They tend to be commercialized more frequently, and they tend to be built through follow-on innovation. That's particularly the case for large firms who appear to accelerate valuable patents and delay lower value ones, presumably because they have reasonable knowledge about the commercial potential of their patents, and they want to get to market quickly and start competing on the basis of those innovations. But when we look at small and domestic firms in particular, we find not only are these innovators more likely to delay than your large foreign firms, but for them, delays typically predict better post-grant outcomes. They're more, those patents that are delayed are more likely to be renewed for longer. They're more likely to be commercialized, and they're more likely to be built on in follow-on innovation. And that makes a lot of sense. Often it's the case that when startups are seeking, they want to establish patent claims at the same time that they're seeking to secure finance for ongoing research programs, to form commercialization partnerships or obtain commercialization resources, and through that phase, they're managing a lot of uncertainty around which inventions to progress. Often startups are engaged in more novel invention, where there's more radical innovation, where there's more uncertainty, and so having the option to manage the patent timing gives them the ability to kind of sequence the patent process in a way that is aligned with the kind of startup journey and managing uncertainty and costs through that process. But for IP Australia, the trade-off is really clear, right? So on the one hand, we want to support small innovators by providing this flexibility, but we also know that delays can have the effect of slowing and narrowing follow-on innovation by others in the market. And in fact, that is one of the central findings from this study. So, it's important for us to understand how these benefits to different costs and benefits to different stakeholders are balanced through the design of the system, and where we can and make decisions about how we best support innovation in Australia. One of the important caveats to that finding was that when patents that are maybe delayed here are granted in other jurisdictions, then that seems to mitigate this effect of delays on follow-on innovation by competitors. And so that really highlights just how interdependent different national IP systems are, and how vital it is that there's kind of global coordination between IP offices and between governments and industry having a say in that process in shaping the kind of global framework. So, key takeaways from the report, just to wrap up. The findings in this year's report, I think, reinforce how crucial flexibility is in helping innovators to navigate uncertainty, to pace their innovation, and extract value from their ideas. And of course, the adaptability of the system to meet changing technology needs is also something that is very much in our minds. I'm really keen to hear your perspectives, how innovators you're working with are navigating this very unique economic and trade environment, what you're seeing inside your organizations and sectors, and how the IP system may be helping to meet those needs where there may be room for improvement, and more broadly, stories about how IP is being managed at the front lines.